Hello and welcome to the Inventorpreneur series. Stories about inventors and others associated with the inventions from mind to market. This is episode 4 and I'm your host Venkat. And today's guest is someone I knew from my master's degree days. Though he was in a different stream, we never crossed paths until both of us chose the same stream and started discussing about the patents. Um, Talking about the guest, he received his master's MSc Physics from IIT Madras, earned his PhD from George August Universitat Göttingen, worked as a patent engineer and now as European patent attorney and UK patent attorney, and currently is working for a Grunecker law firm based out in Germany. Happy to have you, Dr. Jegannath Korukottu, on the show. Welcome, Jaggu. How are you doing today?
Thanks for the intro, Venkat. I'm doing very well. How are you doing?
Thanks. Doing well. So, Jaggu, jumping right into the show, can you share us your career path and how the shift from lab bench to patents happened?
Indeed. We both know that how our PhD life takes us through ups and downs, and at some point you may have entered your research career with a vision in mind to do something great in your scientific career, but this does not always pan out like that. And we always choose some alternative career in science because we are basically scientists, but somehow want to be as close as possible with science. So that's why I had two options. So one was to go into business consulting, and one was being a patent attorney, so to speak. That's how after or close to my PhD, I tried both avenues, and I did some internship in a small law firm in Düsseldorf to see how a patent attorney uses his scientific knowledge to assess patents, and that's how I got into a patent profession. So I did a very small internship for 2 weeks and worked very closely with a well-known patent attorney who was in chemistry stream, and he taught me, within these 2 weeks, he taught me how I could use my expertise in this area, and that's how I got into this patent profession. He referred then me to Grunecker and said this would be the right firm for you to explore in this profession, and that's how I joined as a patent engineer, and then I qualified as a European patent attorney, and then later on as a UK patent attorney. I'm in this profession now since 2009, so it's almost 12 years.
Great, Jaggu. Here, can you declutter us a bit about this European patent attorney and a UK patent attorney? What exactly are these? And also, can you walk us through the process of how you appeared for this patent attorney exam? How different that is compared to the Indian patent system? Maybe I can explain how the Indian patent system here works. So in India, if you have to appear for the patent agent exam, all you have to do is just clear at least have an undergraduate degree, and then appear for this patent agent exam, which happens once in a while. It doesn't happen every year. Be once in 2 years or 3 years. There is no specific pattern to it. So can you shed us more light on this? What exactly is this European patent attorney system, and why do you call yourself as a European patent attorney and also UK patent attorney?
Right. I think that's a very good question. There are several avenues to become a patent attorney. As such, if you are based in, for example, Germany, France, or UK, or any European patent contracting states. So since I'm based in Germany, I could speak with regard to Germany. So in Germany, there is, if you want to become a patent attorney, there is two ways. So one patent attorney, which is a German patent attorney, and the next is the European patent attorney, which is where your proceedings are before the European Patent Office. And these are two different streams. So if you want to become exclusively a German patent attorney, then you have to join, of course, a firm like Grunecker, and you train with the German patent attorney, exclusively on German proceedings before the German patent office, before the federal court, and before the result of the high courts. And then you also spend at least 6 months at the patent office, at the federal court, close to the judges, and you involve in the proceedings and help the judges, and therefore you gain all these experience, and then you become a German patent attorney. And then there is a European patent attorney. For this, so I'm not going to focus more on German, but more on focus on European patent attorney, how to become European patent attorney. To become a European patent attorney, you should have at least a master's degree in science. I think just a bachelor's degree will not be considered, but you should have a master's degree because in Germany or throughout in Europe, master's degree is considered as a focused studies. So you get a broader picture in your bachelor's degree, and then as a master's student, you do a thesis. So what they expect a patent attorney to have is at least a skill to analyze technically and being analytical in your chosen field. And that's the basic. And then once you have your master's degree in science, so it can be physics, chemistry, or biology, just a computer science was not enough a few years ago, but now just a computer science is everywhere, which I hope we may talk later about software and so on. So also a software degree is now recognized as a science degree. And once you have the master's degree and then you apply to a firm like this to become a European patent attorney, then you become a patent engineer. That means you stay with the firm and gain experience before you give your qualification exams. To become a European patent attorney, you should have at least 2 years of work experience. That means you should have worked with or under a European patent attorney on all European proceedings. For example, right from drafting, responding to office actions, oppositions, and general legal advice. So, and then you can give a so-called pre-qualifying exams, which happens 2 years after you start your profession. And once you successfully pass the pre-examination, then you can give the full qualifying examination, which is after 3 years. And this consists of 4 examinations. One is on drafting, and then one is on responding to office actions, and one is oppositions, and one is legal advice, which is exactly what I said. You get trained for these examinations during your first 3 years. And once you sit these examinations, which is not so easy to pass, because as you can see from the statistics, the pass rate is only about 25%. So the exam really tests your skill and under time pressure as to how you answer and give efficient legal advice and efficiently solve all those responding to office actions, oppositions, and drafting. And after all this, you become European patent attorney, and that gives you the right to represent your clients before the European Patent Office. So this is the path to become a European patent attorney, which may seem long, but the first 3 are so very crucial. How well you train, and I think that's not easy to obtain just with your bachelor's degree or just your master's degree, but you work like a patent attorney before you become a patent attorney.
So Jaggu, the significant takeaway from what you had just explained is that in European patent system, at least one needs to have a master's degree, which is at least exposure towards writing thesis, and also the candidate has to work in a firm as a patent engineer for at least a couple of years before they appear for the patent attorney exam, which is significantly different from the Indian patent system, where as long as you hold a bachelor's degree, you can right away appear for the exam and then you become a patent attorney. So this is the stark difference I find in the system. And also one thing which maybe you can clear it out for all my listeners is how frequently this examination is conducted.
On the first point, you're absolutely right. I think the focus is mainly on you being able to write a thesis on yourself on a very specific technology or very specific area in your chosen field, and train as a patent engineer. So that's what I ended, that you work like a patent attorney before you become a patent attorney. That means you should be able to handle all avenues of being a patent attorney, such as drafting, responding to office actions, handling the oppositions, which is not an easy task, and giving a comprehensive legal advice on patent-related matters. And as to the frequency of the exam, so the pre-exam, which was only recently introduced, and this happens every year, so once in a year, and also the final EQA exams also happens once in a year, which is usually at the beginning of spring in Europe. So that is between the end of March or the beginning of, between end of February and beginning of March. And there is usually 1 week just scheduled for this EQV. Maybe the Monday is the pre-EQV, and the Tuesday, Wednesday, and Thursdays are for the other EQV exams. So that the 1 week is compressed just for your EQV, and candidates start preparing for this EQV at least 1 year before this time, so that they can focus completely on preparing themselves, getting exposed to all sorts of legal scenarios. Because as you can see from the past question papers, these are of course may look hypothetical, but these questions were framed by the examiners at the EPO, and those are based on their experience and their exposure to the real life cases. So the questions that you do get are already going to make you realize that these exams are not just for exam's sake. You cannot just prepare it from a book, but you can only answer these questions if you have a practical experience. And that's why they maintain that a candidate should have this practical experience at least for 2 years. And when you see the final exam, you have the 3 years. And therefore, and this yearly examination is based on this cycle of training for a candidate.
Just to harp on the same point for a bit, which is this transition of from a graduate student to becoming a European patent attorney and working as a patent engineer. At least this helps someone, at least helps the candidate to decide whether they are ready to make this career shift towards the patent side. This 2 years would give them a good head start to make that decision, I suppose. And also, so when you worked as a patent engineer, sorry to hop on the same point, but just for the clarification, I'm asking this. So when you worked as a patent engineer, how hands-on was your experience in terms of working on cases, and how it helped you to clear the patent attorney exam?
Yes. The training period, it's as I said, it's very rigorous, because first you start with because you are just coming straight from a university, or if you are a master's student, or if you are a PhD student, you are coming straight from a research background, where you are trained to be more analytical and trained to read documents in detail. But being a patent attorney, so the first thing you do is the first few months, they focus on drafting patent application, which is completely different from writing, for example, a master's thesis or a PhD thesis, or even a scientific journals or papers that you present during your PhD. So here the focus is on how to write in very simple language invention in detail. So for example, first you learn how to read claims and how to write claims. Just they tell you, give you an arbitrary inventions and ask you to perhaps write few sentences about this invention, and that's how you slowly get into this mold, that you read a lot of patent applications and see how they are drafted. You read the bad patent applications, good patent applications. Of course, at that stage, you don't know what is good and bad, and you don't know how a patent application looks like. But your main task is just to read as many patent applications as possible. For example, in a specific area. When I started, I was reading patent applications in semiconductor technology, and I came across several applications. And as you can imagine, each patent applications was written by a different patent attorney, and therefore they all look and sound different. But in the end, the idea was that you want to protect a specific device or a specific method, and your focus is always on how can I broadly and cover this invention in a claim, and then in a description. And this already takes at least 3 to 6 months of your first training period to think like a patent attorney, how you can cover, how you can make these claims as good as possible and as broad as possible, and so that it's foolproof. That how you already think like an infringer, you think like a examiner, you think like a patent attorney, and this already gives you a good base. And then to further go on to responding to office actions and then even oppositions, and just during this period you already give legal advices, because the training period was, you can never underestimate. I have seen some candidates who have started, and after a few months they just thought, okay, this is not for me. And I think you need a specific skills and specific mentality to stay in this as a patent engineer, and up to you can go through this examination. And the examination period itself is very harsh, as I said before. So the first 3 years is going to be very I think this is what sets your base for the next decade and also.
As a European patent attorney, where do you practice? What are the restrictions? And maybe I'll throw more light on why I'm asking this question. For example, if you get the license for a European patent attorney system, can you practice in Germany, or you have to validate your license in Germany to practice in Germany?
So anybody can write the examination. So the pre-EQV and EQV. So of course you should be training under a European patent attorney, but your place of business should be in European Economic Area, in particular the European patent contracting states. So the EPC, the European Patent Convention, gives you a certain list of contracting states, and one of them is Germany, on France, UK, Swiss, Spain, Italy, Netherlands. So if you're based in these countries, and each countries have their own national patent system and the European patent system, and therefore you must have a place of business in these contracting states and your license. So once you pass the examination, you go to the EPO and say that I have passed the examination and now I would like to register as a European patent attorney. So that you must give your address or place of business in this contracting state, and these are the restrictions. For example, I cannot practice European or as a European patent attorney based in the US or based in India, for example, because I must have a place of business in this European Patent Convention contracting states. And these are the limitations. And of course, because you have qualified as a European patent attorney, and if you are a national of one of these contracting states, you are entitled to have a place of business. This is just to promote the profession, and therefore each contracting states, once you become a patent attorney, you are entitled to have your place of business in these contracting states. For example, I became a European patent attorney. Now I'm entitled to have a place of business, for example, in the UK, as long as I satisfy the nationality requirements. But I can't go to India and say that I want to practice my European patent attorney title. So these are the restrictions, and these are the place of geographically and professionally restrictions provided by the European patent system.
Can you give us a broader picture of the European patent landscape, like how exactly it works, and also can you explain us the patent timeline structure of both the European patent system and also the national system?
European patent system is an international convention. So it's not a European Union convention, but it's an international convention where all these contracting states, so-called contracting states, have signed a memorandum. Therefore, a European patent application, when you file a European patent application, you, for example, file before the European Patent Office. The patent office is located at the headquarters in Munich, and there are offices in Netherlands, Berlin, and of course, each national offices act like a receiving office for European Patent Office. Each contracting states. So when I, for example, talk about Germany or UK, they have their own national patent system, which only covers, if you file a German patent application, it only covers Germany. And if you file a UK patent application, it only covers UK. But if you file a European patent application, at the time of filing, you can designate or cover all the contracting states. So the contracting states are usually all European countries like Belgium, Germany, France, Luxembourg, Netherlands, and so on, Switzerland, UK, Sweden. But at the time of grant, after grant, you can choose to validate, which means you choose to enforce if it has to in certain countries. For example, applicants traditionally validate their granted patent in Germany, UK, and France, and then the Netherlands and Italy and Spain and so on, depending on the market of their invention.
The second part of my question is the patent timeline structure. How different it is from the Indian patent system. Maybe I can give some head start to this. For example, in the Indian patent system, of course, the term is the same across the world, just 20 years, and we have a publication that happens 18 months after the filing of the patent, and there is examination requirements which can be placed either 48 months from the date of priority or date of filing, and there is expedited examination request. And we have a pre-grant opposition system for which any person can file a opposition anytime before the grant, and we have a post-grant opposition which only a person interested can file opposition within 1 year from the time of grant of the patent. So this is pretty much what I call is a timeline structure of the Indian patent system. So pretty much, can you also compare that with the European system?
So European patent system is mainly followed through the Paris Convention. So it takes into account the priority of the Paris Convention. So you can file a new fresh application as a European patent application, or you can claim prior national application as a priority, or you can enter through a PCT route, which is 31 months after your filing or priority date of the PCT application, and then you enter so-called European regional phase. This is called regional phase because it's not only national, but it has several regions within the Europe EPO. So these are the three routes how you could file a European patent application, in addition to, of course, your national route. And once you file an application, so there is a formal examination where they look at whether you have paid all the fees, whether your patent application complies with formal requirements, which is basically same as the international application, because they have harmonized these to all the WIPO standards. And once you file a patent application, you will be receiving a search report, which is not common to all countries, or which may be different from other countries. So you receive a search report. So you have to pay a search fee at the time of filing. And there is also separately an examination and designation fee, which I would come later. So a search fee is just to give you a search report, and in addition a search opinion, which already gives you within the first 6 months, if it's a fresh application, opinion on the patentability of your application. It lists a set of prior arts and any possible objections, and whether your application has chance to mature into a patent. So you already know at this search stage. I think this stage is something unique to EPO system, that you receive a search report and a search opinion already at the early stage, before publication for a fresh application. And then once you receive the search report, and then you have time to decide whether you want to continue with your application. So you continue with your application either by paying the examination and designation fee. So the designation fee is the fee which covers at the filing stage or during this prosecution stage all the contracting states, so that you are we involve all the national offices. So you pay the designation fee, and the examination fee is to move to the next stage, which is the examination stage. And then the patent application, of course, publishes after 18 months from the earliest priority date, which is same as the other countries. And then within 6 months from publication, you must pay this examination fee and the designation fee. And then depends on the workload of the examiner or the technology area, the next examination reports or may already be coming. So, for example, you must respond to your search report at the time of paying the examination fee. Therefore, this amended set or this response to the search report acts as the basis for your further examination. So, if the examiner is convinced, then you immediately receive a so-called intention to grant. Then the examiner will send you a text on which he or she intends to grant this application. Or if it's not, then the examiner may issue examination report detailing further objections. Or in case if the EPO wants to speed up this, then they already issue a summons to oral proceedings. So each applicant are entitled, if they request, they are entitled to oral proceedings before the examining division, so that they can convince the division as to the patentability of your application. So this procedure goes on iteratively. And then you reach the grant stage. And then at the grant stage, you must file a German translation of your claims and French language, because these are the official languages of the EPO. So you can do the proceedings in German, in French, or in English. For international applicants, it's always English. But for local Germans and for European countries, they either use Germans or French as the language of proceedings. And therefore, to give a fair picture for whole European countries, they ask you to translate into 2 other language of the EPO, the translation of claims. And then you decide to validate your patent. So once you have a European patent, so there is no one such thing called a one European patent. So it becomes a bundle of patents after it's granted into national patents. For example, if you designate after your grant into Germany, France, and UK, then you have 3 patents, each valid for these 3 states or 3 countries. And then you pay your regular renewal fee, annuity fees, then so that you can maintain the pendency or these of your patent in these countries. So this is the timeline which is generally followed by the EPO. And just for prosecution, there is no such thing called pre-grant opposition as such, but one can always file before grant a third-party observations. For example, if you as a third party found some very important prior art or even prior use or even prior very important prior material that questions the patentability of this application and which was not found by the EPO, or even if it was found by EPO but you still think for some reason it's very important, you can always file such observations before grant of the application. And what this then does is it indicates to the examiner that maybe he or she may have overlooked some things, and this could give rise to a further examination report. So that if these arguments are convincing, the EPO examiner would issue a further examination report, basically agreeing with you or maybe supplementing to your argument, saying that this prior art seems relevant for questioning novelty or inventiveness, and therefore the examination would continue. The drawback, however, is as a third party, you will not be party to these proceedings, even though you're still called a third party, but you are not party to these proceedings. What this means is that the applicant can respond, but the EPO will not consult with you. So it's the discussion would be still between the examiner and the applicant, but your arguments will be considered as a third-party argument. So you will not be able to take part, for example, to give some further evidence or further arguments. For that, you have to file a further third-party observations. But this is a very good tool if you have a very important prior art which was not found by the EPO, and in most of the cases, the EPO considers this document or documents if they are really relevant to question the patentability. This usually happens, for example, in former times when only machine translation was used, for example, for Japanese applications or Chinese applications, and still the EPO was not able to find these documents. But now with the high-tech search technology used by the EPO, all these documents are already part of these search report. But still, time to time, some journals could be missed by the EPO, and those becomes a really important prior art, which may lead us to a very narrower claims for these applications. So this is a very good tool. And then you have, after grant, if you want to oppose the grant of the patent, then you can file a opposition against the patent within 9 months of the grant of the application. So you can file anonymously, or you can file on behalf of a corporate or on behalf of the opponent. You can file this opposition, and then this becomes next stage of the proceedings. So what it means is, now you have, if there is one opponent, then you have three parties: the opposition division, you as an opponent, and then the patentee. And the discussion should be among three of you to reach a conclusion as to whether the patent should be maintained or revoked, or maybe maintained in amended form. So this is a different procedure, and this is also very unique to EPO, the centralized opposition. And if you manage to oppose or revoke this patent centrally, then that means the patent, it becomes patent as if the patent never existed in Germany, or that the patent is revoked in all these three countries if you have designated all these three countries.
Okay, just to clarify on that aspect, which is a third-party observation, which you mentioned, which is almost like a pre-grant opposition. In India, any person can file that pre-grant opposition, and in the case of what you called as a third-party observation, who exactly is a third party? And also you mentioned the post-grant opposition, which happens 9 months after the grant of the patent. So both the third parties are the same, or you call this person who is opposing before the grant as a third party, and what do you call the person who opposes after the grant of the patent? Is there a technically a different term used? Because in India we call before the grant as any person, and after the grant whomsoever opposes we call as any person interested. So if you can clarify on that.
Yes, before grant it's called a third party, because the discussion is always between the examining division and the applicant. So there are two parties, and therefore if a third party now comes and says, so the third party could be singular or plural. So there could be multiple third parties who could file observations against the application before grant of the application. So he could be a potential or a future opponent of the patent, or she may want to be or a competitor against this applicant. And this third party could be anybody, anyone. Of course, it's not the applicant himself, but it can be anybody who's other than the applicants. And they can file these third-party observations. And as I said, they do not become the party to these examining proceedings. So to become the party or to become the voice, then they would have to file an opposition if this patent application was chosen to grant. And this opponent again, so we use in the EPO pre-grant it's third parties, and post-grant if an opposition is filed, then they are called opponents or opponent. And then there is a patentee, who is the patent holder, and then opponent and opponents, and then there is opposition division, which is comprised by the EPO members. And then the opponents become party to these proceedings. And again, they could be the competitor of the patentee, or there could be in the line of supply chain of this patent technology, or they could be also anonymous. Maybe sometimes maybe they are licensing, or they are collaborators in some area, but they don't want to reveal their identity, but still don't want this existence of this patent, so they could still file anonymously through a patent law firm or through a special service providers. They can still file position against the patent.
Similar to the post-grant opposition system in Europe, in India, similarly, you have a 3-member opposition unit chaired by the controller. Controller listens to the opinions of this 3-member unit based on the opposition that was filed to them. And you have a patentee and also opponent. So, and the hearing happens this way. So, can you share us the ecosystem in Europe? Who files maximum number of patents? Academic institutions, corporates, or startups? And also more information on how exactly education institutions view patents and IPR rights, how the ecosystem is built in Europe. Yeah.
All right. The EPO publishes every year statistics on who was the top applicant of this year, the number of applications filed, and I can say from the 2020 statistics, there are quite a so the top applicants. So usually it's the top corporates. Like I think for 2020, Samsung was the top filer, who filed nearly about 3,300 applications. And then followed by Huawei, they also filed close to 3,000 applications, and then LG, Qualcomm, Ericsson. So it's always the high-tech companies from all over the world. They are the top applicants, and they come from. They're not just restricted to the European countries. For example, Samsung is from Korea, and then Huawei from China. Again, you have LG from Korea, and Qualcomm from US. And the top German companies are Siemens and Robert Bosch, and then there's Philips from Netherlands, and then chemical company BASF. So you can get a list of all these top applicants filing applications before the EPO. And there are of course academic institutions like Fraunhofer Institute files is the top academic institute filing European patent applications, and there are many universities for example, from France and also from the US. There are quite a number of universities, and what is hidden between these numbers are how much the universities collaborate with these top corporates. The universities, each or almost all the universities, have their own tech transfer division, who license or who commercialize or even who assign these rights already to these corporates. So you don't get the full picture of where the invention originated. So for example, when we say some invention belongs or some patent application was filed by company A, but this might have a different origin. Maybe a university B was behind developing this application, and then it was later assigned to company A, and therefore for statistical purpose we see that this application was filed by company A. So this is quite a common trend, at least in Europe, because of the awareness of the IP, that all the universities and the university researchers, they are aware of IP and how one can protect IP and the forms of IP. And the tech transfer division are quite well aware as to how to commercialize or how to make a patent application from the research and translate into a patent application and then translate into a commercial product. And this ecosystem is quite well organized. When I say organized, because I was involved in some, I'm still involved in such activities. So what happens is I have a client who's from a very big university in Europe, and they collaborate with the company always. So what happens is, as soon as they have identified an invention, they immediately assign this invention to a corporate B, and then the corporate B takes over the cost of this application, and they file this application on their name. So the technology is already transferred, and if I look at this number, so or how these educational universities do, they quite regularly transfer this applications or commercialize their inventions more than 60% of the time. So the commercial exploitation is nearly at 91%, and they even generate revenue for nearly 90% of the time. And then they also use these inventions or applications for R&D collaboration purposes, and also for spin-off formation. So quite a lot of university that I advise have spun off many startups from these research collaborations, and these startups then, of course, assign their technology to big corporates or file the applications on their own name. So the options are quite endless. So the top exploitation by these universities is through licensing, and then R&D corporations or joint venture, or even selling their rights through assignments or through licensing and so on. So the ecosystem is quite strong and quite well established, and these are the numbers you don't get just from the statistics.
Jaggu, it is wonderful to hear this relay between academic institutions and the industry, the tie-up they have, and how heartening to hear the kind of awareness some of these education institutions that you had mentioned. Can you clarify to my viewers that do all the educational institutions have the technology transfer office, or only the elite institutions have this technology transfer offices there?
Well, as far as I'm aware, and the universities that I work, academic institutions that I work with, they all have a tech transfer division. So the person you speak at this university is not just the research head of the division, but actual patent person, or who is the person who is aware of the IP. So, for example, I work with a university in which is in the far north of European area, and it's a very small university, but even they have such a well-organized tech transfer division within there. And this tech transfer division is head by a former patent attorney, worked in a law firm before. So the persons that you're dealing with, even a small university region, is aware of the patents, trademarks, designs, all sorts of IP, because the university is very serious about their possible commercial exploitation of their research and development, because they want to have a good ecosystem where they could promote research and development and licensing, and also spinning off of startups from these universities. And this is very important, not just for reputation, but also just for bringing out new technologies. And all these, for example, BioNTech, Pfizer. I mean, BioNTech was a startup some years ago, and now they have came out of university, and they also do quite a lot of collaboration with the universities in Poland, for example, to expand their research possibilities and also expand their product pipeline. So you can see all these big pharmaceuticals or big tech companies, they all have a good collaboration, a healthy collaboration with academic institutions, because they see these as their so-called research grounds. And then they start developing their technology in-house once they have the know-how, or once they have acquired the know-how, or have filed some patent applications, or some assignments, or some licensing. So this is quite important for the universities as well as for the industries to have this healthy collaboration.
Yeah, and in fact, Jaggu, just to put this into perspective, if I have to compare that with the Indian patent ecosystem, of course, I don't have the numbers for the year 2020, but I have the numbers for 2018 to 2019 from the annual report released by the Indian Patent Office. In India, there were close to 50,000 patent applications filed for that year, and out of the 50,000, nearly 35,000 of the applicants were from abroad, foreign applicants, and only 15,000 applicants were from India. And if I have to go deeper into that 15,000 applications analysis, maybe my numbers may not be accurate, but maybe close to 4,000 applications are coming from the education institutions, and nearly 90% of this are coming from the elite institutions like IITs and IIScs. So, yeah, I mean, just to put that into perspective, where you said that almost all the education, even the education institutions just you mentioned, where it is not considered as a elite institution, but still they have a advanced setup to promote the innovation. I hope that Indian patent system, I won't call it just the patent system, the innovation, I believe the engine for innovation must start from the academic institution. So unless the education institutions are in the right frame of mind, or if they are not provided with the right resources, it is hard to churn out some of the quality research products out into the market. With that, let's move on to the other section of this episode, which is basically I would like to dive deeper into some of the European patent provisions. Of course, we did discuss about this pre-grant and post-grant opposition. There is something else which I would also like to understand, which is I've come across this term called the UK IPO opinion. So basically, anybody can challenge the validity of a patent in any European contracting states. Can you throw us more light on that? Like exactly when this happens, who can apply, and what exactly the procedure is?
Just Venkat, maybe I just go back to the former question a little bit when you talked about the Indian ecosystem, about being the quality and the number of applications. If I may add that, for example, in at least in Europe or even the Western countries, they do not worry about the quantity. So what they want is a good quality patent application, because a patent application, or in the end a patent, is your right. So it's your just like a constitutional right, you have your right to stop others or to prevent others from copying, and this is taken very seriously, because you don't want to give up your right or limit your right. You want to have as broad as right as possible. So for example, you want to walk in a normal road and you want to have your freedom. So I think that the right is basically attached to your freedom to operate, right? So these educational institutes, that's why they really strive to get as broad or as quality applications as possible. I think somehow this is linked to their awareness, and already many universities have IP as a standard protocol, IP awareness. So when you join a research institutions, you are already given full information about what are your rights, what happens if you invent something. So these all the researchers are given this awareness, and I think this awareness helps a lot to achieve good quality and high patent system ecosystem in this European economy. I think that's why all the universities are spending or investing their time and effort to bring this awareness at a very early stage, so that in the end the number doesn't matter, but the quality is what very important.
Yeah, you hit the nail on its head. Yeah, it doesn't matter how many applications you file. What matters most is how many gets granted and how many of them go on to find the market. That is more important, which also exactly quantifies the innovation ecosystem you have. Moving on, Jaggu, can you give us information about this UK IPO opinion and how one can validate a patent in Europe?
Yes. So once a European patent is granted, or even national patent is granted, you have limited possibilities to invalidate or even enforce these patents. So one route, traditional route, is so once we want to invalidate a European patent oppositions, but which has very narrow time limit, which is a 9 months time limit within which you would have to bring an opposition against the patent. But what happens if you miss this 9 months time limit? Then you would have to go national route. Let's assume for hypothetically that an European patent is validated in Germany, France, and UK, and then your options are, so as a potential, and if you want to enter these markets and you see that there is a really hurdle, that there is a patent which prohibits or prevents you from entering this market, and you want to clear your way, then you want to invalidate these patents in these 3 jurisdictions. And it's already an uphill battle, because now you have to enter 3 different regions, and each, of course, you go to their courts and question the validity of the patent. Maybe perhaps you bring a nice prior art and questions the validity, but each court can come to a different conclusion. So we have several examples, or in my case, I have seen in the UK it was considered, the patent was considered valid, but in Germany the patent was considered invalid, and in France it's also a different decision. So depending on how the national office interprets the claims, interpret the prior art, or the restrictions and limitations they have, they all can come to a different conclusion. And therefore, enforcing or bringing this validity question at a very early stage is very important. And once, if your third-party observations or even position is about to fail, then you can already ask, for example, a UK Patent Office an opinion on the patent. An opinion, I means you can ask, for example, you can have a product and you can say to the UK Patent Office, hey, I have this product and I have seen this patent and I don't think there is an infringement. Could you please give your opinion on this? And you can also ask, I also have a prior art which looks like takes away the validity of the patent. So I would like to address you. So you can ask the UK Patent Office on their opinion on infringement and validity of a patent. And this is very cheap because it just costs £200, and you have the opportunity to provide almost all your arguments that you would do, for example, in a court, in a high court, or in intellectual property court in the UK, but you still have the option to communicate in writing to the UK Patent Office on all these aspects without even going into the court. So this helps that you can use this as a very good tool at a very early stage to question this validity and ask a non-infringement opinion on the product or process or any commercial product that you have in mind, and you want to bring this into the market.
Okay, Jaggu, I'll come back to this. I'll come back to your answer a little later on. Who can file this opinion to the European Patent Office? But before that, this is one question which I wanted to ask you right in the beginning, but let me just clear it out of my way. So, what are the effects of Brexit on the non-European patent applicants in terms of cost, ease, and convenience?
Well, as I said at the beginning, European patent system is not a European Union system, but an international contract. So Brexit does not affect the European patent system route at all. So the applicant has, or at least the patent system, European patent system does not change because of the Brexit. But the trademarks and designs routes. So traditionally, you have, because let me go back to the patent. Why? Because there is no European Union patent yet. There is still questions or topics, or there is still discussions going on as to this unified patent code and unified patent system. But this is at the moment on hold because of various reasons. One is the constitutional claim brought by person against this German ratification of the European Court, and also the exit of the UK from the European Union has cast a doubt. But this is the topic for a different day. So there is a unified system or a community trademarks and community design system, but this the Brexit has affected this system a little bit, because now a European Union trademark does not give you protection in the UK anymore after Brexit. So you would have to file, or one would have to file or get a protection, special protection in the UK, and therefore there is an additional cost for the applicants to get these UK protection for their designs and trademarks. And also with regard to representation, they would have to find a UK attorney, UK design attorney or trademark attorney to represent their rights, and this has added additional cost to their trademark and design portfolio. But when it comes to patents, the system remains as before.
Yeah, I mean, I completely understand. There are many layers attached to the many sub layers that we can get into the discussion, but unfortunately we don't have enough time to go into the details of everything regarding the European patent system. So that is why we try to stick to the broader outline of this. But maybe now is the right time to ask you your domain expertise, and especially I know that you work in the area of softwares and medical devices. So in India, especially under Section 3K of Indian Patents Act, prohibits inventions that are related to computer program per se or algorithms. So can you share us the European patent perspective on this in regard to software?
Yes. I think that if I'm right, please correct me if I'm wrong. The Indian patent system and the European patent system, when it comes to these patentable inventions, are quite harmonized or quite almost the same. So that means that a program or a software program as such is not patentable, but if you can establish a technical effect or a technical implementation, or if the invention solves a technical problem, then you can of course patent those software related inventions. For example, let's say if the invention is a computer program and it does something specific in the computer itself to enhance the technicality or to improve the technique or to improve the functioning of the computer itself, then it is patentable. And on the other side, if it has a technical implication, maybe I can give an example.
Yeah, that would help. Yeah.
I mean, the classic example is always this image processing. So you can write a program to, for example, improve the background music recognition videos. Those are technical because you are working with the technical details and you are improving some technical aspects of a system. Those are patentable. But if you just, let's say you write an algorithm to display or to present a data model, this is not patentable because this is just a display of information or a presentation of information which does not solve per se a technical problem. Then it is not patentable by software. And I think I have also worked on some apps, for example, mobile phones or apps where you let's say you display some information on your mobile so that it can tell the user that it's time to stop or it has some implications. Then these are called some interfacial applications. So you displaying the user interfaces to maybe to quickly do something. So this is something very technical, and therefore these such kind of apps would be patentable. And the same also with navigation systems. So you're just informing the users about something. It's not technical because it's just the way of doing things. But if you improve the navigation system itself, for example, you use your data such that you provide an advanced recognition of hurdles, then this is something, it solves some technical problem, and therefore it is patentable. So in the end, it all comes down to two steps. Is it technical? If my claims have technical features in it, and if yes, does it solve a technical problem? So this is so-called two hurdles approach followed by the EPO case law. So as long as these two criteria are solved and you can cross these two hurdles, then you are already in the patentable area in the regime. And you said already touched upon the topic the beginning that I work mainly on medical devices area, on also in mechanical electrical area, and these days almost all the invention has some software related matters attached to it. For example, I work quite on medical devices, and these are devices which measure some parameters on human body or patients. And in the end, somehow these data are manipulated or controlled by a software system. So I work quite regularly on these interface regions where the medical devices and softwares have some interplay, and always come across situations where I have to argue how my software related aspect is patentable because it has some implications into medical technology. And vice versa as well. So sometimes it's just already existing medical device, and you just maybe provide an improved app or improved algorithm, and then I have to argue why and how this algorithm helps in achieving improved efficiency for my medical device. So I think one cannot ignore a software patents anymore like in the past, because all these software invention have some implications or in the end tend to solve some technical problem. So as a European patent attorney working in this interfacial region, I always tend to find what is my invention, what are the technical features, and how does it solve a given technical problem. So if you can break this down into these two questions, then you can already answer whether it would be patentable or not. I assume this is the same also with Indian patent system as well.
Yes, I mean, more or less it's the same. But of course, as you know, my domain is in chemical, pharmaceutical, and life sciences. So yes, pretty much that's what the manual also says. As long as it has some utility value, and as long as the software is integrated to provide some function or means of understanding the function of a system, yeah, it falls under a patentable subject matter. Jaggu, moving on, which is totally on a different topic. Recently, I came across a report on virtual conferencing versus in-person opposition proceedings of nearly 1,000 cases between May of 2020 and April 2021. What exactly is this report, and can you shed some light on that?
Yes, I think, Venkat, you're talking about video conferencing at the EPO. And if I give a little bit background, EPO, as I said at some point when I talked about the timeline of the EPO, so the EPO holds oral proceedings before the examining division or opposition division or appeal board. And traditionally, these are face-to-face proceedings. So where you plead your case before these divisions, and time to time for the examining division, would be in Netherlands, and I would be in Munich, and I would propose them to hold the oral proceedings via video conference. And this was possible for almost most cases. Depending on the complexity, then they would decide maybe this would be good if it's held in face-to-face. But during the pandemic time, and because there are quite a big to avoid quite a big backlog, what the EPO decided was they would decide whether the oral proceedings would be held by video conference or not by themselves. And for some cases, like in opposition, they would ask for the consent by the parties whether they would agree or not to the oral proceedings to be held by video conference. And for the pandemic time, what happened was some party chose to give their negative consent. That is, they did not agree to video conferencing for some reasons, like maybe they thought it would be effective if we are face to face, or maybe the complexity of the case is such that they would have to invite several parties, like maybe they want to have a witness, they want to have a technical expert with them, and to organize all these, they thought maybe video conferencing was not ideal for a particular case. And this led to a heavy backlog or postponement of many video conferencings, oral proceedings. And therefore, EPO decided maybe we should not ask for their consent, but we just say this will be held by video conference, whether you consent or not. And I think this is a topic which is still being contested. And actually, next week on May 28th, there's going, or no, this week, so this Friday. So this Friday, there's going to be a public oral proceedings, which is being held in video conference to decide whether the oral proceedings via video conference is legal or not. And if you ask my opinion as to what is important, I think it's important what the applicant or the opponent or the client in general wants. If they want to have, if they want to give their consent, they say, Jag, if you please go to attend the oral proceedings, even if it's video conference, because this case is important and we want to have the decision as soon as possible. We don't want to have postponement. Then we, of course, we comply with the client and say we attend the oral proceedings. And in some cases, it may happen that no, we have some experts coming and we want to have them present with you, and therefore it would be better if we have it by face to face. Then it's happened face to face. But regardless of that, the quality of the EPO's video conferencing has been quite good. I have attended several oral proceedings via video conference, and they were really well efficiently organized by the EPO, and you can present your arguments quite well. Of course, there are some technical difficulties time to time. Maybe some cannot hear us properly, or the internet connection is not ideal. I think these are expected when you use technologies. So I think in the end, we should use technology where it is available, and if it solves the problem in hand, then it is quite
right. Even the data seem to suggest what you had just mentioned, with more or less thousands proceedings, but the data is a bit skewed towards the virtual conferencing, whether that led to successful grant or successful amendment of proceedings. So I'm pretty sure that some good outcome would come out of this. Moving on, Jaggu. So almost we are nearing the fag end of this episode. So what is your general advice for Indian applicants entering national phase or conventional route to Europe? And what are the best economical practices?
Well, that's a very good question, Venkat. I think I have come across various questions in this regard. I think the main aspect is always, as I can understand, that Indian applicant has some concerns about the cost when it comes to EPO, because the EPO is not cheap at all. They have search fee, they have examination fee, designation fee, and then you add the attorney fee on top to these applications. The cost of a European patent application in the end up to the grant may cost up to nearly in 5 digits of thousands euros, in the lower 5 digits, and that's quite a lot of money for a single patent application. And there are several aspects one could think about before considering how to go about it. For example, yes, so you can enter EPO regional phase via your PCT application, or as I said at the beginning, you can, if you already know what is your market for the product or the process or the application or the invention itself, then you can already decide. Let's say if you have a very great invention and the only market it's in the UK, for example, then it doesn't make sense to file an EP application, because eventually your market is only UK. And I would already advise to file a national EP application at the UK Patent Office instead of filing EP application. The reason is that the search fee is nearly 10 times lower than the EP application. The examination fee is nearly also 10 times lower than the EP application. And therefore, the renewal fee, the annuity fee that you pay at the EPO is quite considerably high, and you can already avoid all these costs just by directly filing a UK application in this case. And the quality of examination is as good as the EPO, and you can also reach a decision very quickly at the UK Patent Office. And same also, if the market is only in Germany or it's only in Germany and UK, then you already can consider filing a national application, regional application, instead of going via EPO route. But if you do decide to go to EPO route, then there are some aspects to reduce cost. Like you can already address the PCT written opinion at the time of entering the EP national phase, so you can avoid one round of examination report. You can reduce the number of claims to 15, because claims 15 onwards you pay additional claim fees, and you can already tweak your claims a little bit to comply with the clarity requirements, which is always raised by the APO. And if you already know the prior art, which may be important, you can already address them in your claims when you file the EPO national phase. And then there is the possibility of accelerating your prosecution. So there is a system called so-called PACE, which accelerates your prosecution of your application, so that you reach the conclusion as early as possible before the annuity fees going into the 4 digits and higher 4 digits. So these are the aspects one could think about when entering EPO national phase. You already should know what is your market, what do you want to cover in your product or process or in your application, and already tweak your claims a little bit so that to address any potential lack of clarity and so on. And so all these could already address or reduce your cost and already channelize your patent application accordingly before these offices.
That is insightful, Jaggu. Maybe let me pose this philosophical question. This is my last question. Give us your perspective towards patents from 2 different vantage points. One, when you were a graduate student, and now as a patent attorney. How your perspective towards patents has changed and evolved over time?
I think I touched this point very briefly at the beginning, because as a graduate student or as a research associate or research PhD researcher, you focus on details, you focus on technical details, you focus on the content, in the sense that you want to show to the world what you have done already. At that time, because of lack of awareness or because of lack of involvement in patents, you know that a research paper or a research thesis cannot be directly translated into a patent. A patent is different. You only need to give only sufficient information, because as a graduate student, you want to give enough more than enough information, the complete information. But so what I've seen that I don't have to include. So as a graduate student, what I'm saying is I want to include as many details as possible in my thesis. But this is, but then I see now as a patent attorney, I would say, no, you don't have to include as many details as possible. You only need to give enough information so that you can safeguard your know-how. So never give up your know-how. Of course, patent is a great tool, but giving away your know-how already means that the future patent applications may not be as impactful as your know-how. So you should protect your know-how somehow. And this view has changed from me as a graduate student, and now if I were a graduate student or if I am a PhD student and I'm writing my thesis, then I would see what is relevant for this thesis, and should I have to give all this information in my thesis or not. So I would give only sufficient information and only relevant information, And this also applies now to even when I'm writing a patent application. So when I talk to an inventor who is a graduate student or who is a researcher, he or she tends to give a lot of information which may not be necessary. And I think also when you go to a conferences, you talk to people and you disclose some confidential information, and those awareness. As a patent attorney now, I advise my clients to disclose only relevant information. I think this perspective has changed with me, that you don't have to disclose everything, but only enough and sufficient information.
Great, Jaggu. With that note, I would like to thank you for your time. Of course, the sky is the limit for discussing the European patent system or the Indian patent system. But considering the limited time we have, I think we have tried to touch upon some of the important aspects. And again, I need to thank you for your time, for giving us some perspective about the European patent system and the innovation ecosystem in Europe. Thanks, Jaggu.
Thanks, Venkat. I think it was a great opportunity also to catch up and discuss on various topics, and I really enjoyed, and I hope the listeners also enjoy these topics. And of course, as you said, we could not cover everything because it's limitless, the topics are limitless, but I would be happy to discuss any points offline or even in a separate podcast later on to address any specific issues to listeners or to you. So I'm happy to contribute to this discussion anytime.
Thanks, Jaggu. And again, to all my listeners, of course, I get to work on these episodes during weekends, and I'm working hard to be consistent with putting out the contents. So bear with me. So I have many other guests lined up for this series. And for those who have not listened to my other episodes, go to the Inventrepreneur channel and you'll find my other episodes. I'm pretty sure there are a lot of significant takeaway from this episode with Jaggu. Thank you all for tuning into this episode, and do catch up for other episodes coming your way. Thank you.